Hi, everybody. I'm Kevin Karanka, and I'm a partner in Husch Blackwell's Labor and Employment Practice. Welcome to the fourth webinar in our six-part L&E webinar series. Before we begin, I'd like to go over some housekeeping items. So first, you'll find links for registration and the recordings for the whole webinar series under the resources folder. Recordings will be available after each webinar is completed. And at the bottom of your audience console, there are icons for you to use during the program today. If you have any questions during the broadcast, please submit those via the question box. We'll try to answer those throughout the webinar today, but if a full answer is needed or if we just run out of time, we'll answer them later via email. A PDF of the presentation is also available to you there in the resources folder. This program has been approved for HR and legal education hours, and to report those, just click on the CEU icon at the bottom of your screen, and a certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with the recording of the webcast. Toward the end of the program, please be sure to complete our short survey. We value your feedback and take that to plan future programs so that they're applicable to your business needs. That's it for the housekeeping items, so let's go ahead and get started with our program. Joining me today are my colleagues Leslie Bask and Cooper Page, and we're excited to be talking with you today about legal updates in Texas. Cooper and I are first going to talk about some significant cases that have been decided this year in the state, and I will go ahead and kick it off first with the McAllen Hospitals case, which is an interesting one. As you guys know, employers routinely attach no contract disclaimers to documents like employee handbooks or offer letters. It's documents that might otherwise resemble contracts, but we use these sort of disclaimers, and they're really important to support any arguments that these documents or these policies and procedures and the related documents around them really aren't intended to be contractual promises. So the McAllen case, that involved 4 employed nurses who worked for the hospital for many years and were paid for many years based on the number of hours that they worked. In their lawsuit, the employees alleged that the hospital actually promised to pay them annual salaries rather than by the hour, and that the hospital breached a contract in that regard. They based this argument upon these annual performance reviews primarily, which contained a blank at the top where the employer inserted, what the annual rate of pay was for these employees. The hospital's response to that was that we use those documents to just establish, what the annual pay would be, but then we divide that back out by 2,080, 52 weeks, 40 hours a year, and that's how we come up with these employees' hourly rate of pay. And the hospital said, and even if that wasn't true, look at our handbook. The handbook says performance reviews are not contracts. They're not promises, to provide a salary increase or continued employment. The employee handbook similarly had another provision in it that said, this is not a contract of employment. These are just informational guidelines. Nonetheless, the jury agreed with the employees and awarded them almost $400,000 in damages for unpaid salary. The employer then appealed the case to the Court of Appeals, who agreed with the jury again, and the employees, found that with these performance reviews that have this language in them, they would enable a reasonable juror to find that the hospital did promise to pay these employees a fixed salary. The employer took the case back up to the Supreme Court of Texas Supreme Court, and the Supreme Court disagreed with the trial court and the lower appellate court. It reversed and rendered the judgment in favor of the hospital, essentially nullifying the jury's verdict. And the Supreme Court really focused on this no contract, disclaimer language that was in the performance reviews. You'll see the quote there. The question was whether those performance reviews could provide evidence, by the hospital that they promised to pay a fixed salary. But the handbook expressly says it's not a contract, and so it barred the jury from giving any weight to those performance reviews for that purpose. Ultimately it said, given that disclaimer, no reasonable juror, the opposite of what the Court of Appeals said, could infer an intent to contract with the nurses for fixed pay. So the court found the evidence was legally insufficient as a matter of law, reversed it, and wiped out the verdict, and the case is now over. So that's a big win for employers. The next case, or actually cases that I wanted to talk about, deal with the employee and independent contractor issue that we've seen. It's been a hot topic for the past few years, given the prevalence of the gig economy. Here we have two cases, both involving the same employer, Greater Houston Transportation Company, who operates as Yellow Cab in Houston. In those cases, the plaintiffs brought personal injury actions actually against the Yellow Cab company, alleging that their drivers, caused accidents which injured these plaintiffs. Of course, the Yellow Cab company comes back and says, well, hold on a second, those drivers are not our employees, they're independent contractors. And so we can't be liable for their conduct. The courts then, went through an analysis on, well, were these drivers really employees or are they really independent contractors? In the Perez case and the Steele case, both involved identical independent contractor agreements, whereby the cab company provided the vehicle to the worker, provided a taxi license or a taxi permit that it licensed to the worker, to the driver. Really where the difference is in Perez, the cab company also provided all the equipment in the car, like the GPS system. They had a computerized dispatch system that told them when and where to pick up fares. But the driver in the Perez case testified that computerized dispatch system provided by Yellow Cab, while he wasn't required to accept every fare that popped up, if he didn't accept a fare, then Yellow Cab had the ability to go in and basically turn off the dispatch system to his car for a number of hours, thereby, because almost all the fares that he would pick up were from the computerized dispatch system, thereby basically, not allowing him to work for a certain amount of time as a penalty for not picking up a fare. And so the Perez court said, look, that sort of control over somebody's work hours, their ability to earn a living, that is close enough to us to create a fact issue. We're going to send this case back down to the trial court, and the jury needs to decide whether this person was an employee or independent contractor. The Steele case out of the sister court of appeals in Houston, reached the opposite result, exactly the same contract, and it acknowledges that its sister court reached a different result, but it distinguishes its finding on the fact that the driver in the Steele case didn't provide testimony similar to the driver in the Perez case. There was no evidence about this exercise of control over the dispatch system, over the routes the cars had to take. And so I thought that was interesting, two the exact same contracts, but we end up with a different result just based on some testimony that a driver gave in one case. Of course, in this analysis, contract language isn't determinative. You have to look at the test. You can't just say somebody's an independent contractor in a contract and make it so. You have to run through the test, and Texas looks at the common law right of control test that everybody's pretty familiar with, the 5 factors. I want to mention the 2019 Super Shuttle decision by the NLRB sort of shifts its test to focus more on entrepreneurial opportunities for gain or loss. If they're more entrepreneurial, that suggests an independent contractor status. If there's more control, of course, it's going to lead to probably an employee finding. And finally, the Fifth Circuit in 2019 adopted this economic realities test in the Premier directional drilling case. That case involved workers who were drilling consultants. Some of them were independent contractors, some of them were employees. And the company, the putative employer in that case, admitted that, look, these people's job duties are exactly the same, but some are independent contractors and some are employees. The distinguishing factor they drew upon was the independent contractors had the ability to turn down assignments, had the ability to negotiate pay without any sort of negative consequences to the worker. And the Fifth Circuit in that case said, focusing on the economic realities of the situation, those 2 factors, the ability to negotiate pay, the ability to turn down work, that was enough to make these folks independent contractors, even though they were really doing the same thing as the other workers who were classified as employees. So just real quick before we wrap up, just recently, a couple weeks ago, the Department of Labor rolled out this new proposed rule on the independent contractor issue. It's been fast-tracked. We think it's probably gonna, if it goes through, it'll be going into effect probably in January. They now want to focus on economic realities like the Fifth Circuit. The DOL says you need to ask, are workers in business for themselves, or are they economically dependent on the employer? And if that question's hard to answer or is unclear, then you're going to focus on the 5 factors, but really on 2 of those 5 factors are the most important: the nature and degree of workers' control over the work and their individual opportunity for profit and loss. This proposed rule would only change the test for the Department of Labor for wage and hour purposes, but it is consistent with other developments we've seen in other cases in parts of Texas. So with that being said, I'm going to turn it over now to Cooper. He's going to talk about some additional notable decisions from this past year.
Thanks, Kevin. So there have been a number of notable decisions recently related to the administrative procedures that occur before a lawsuit, either before the EEOC or the TWC. The Texas Supreme Court previously suggested that timely initiation and exhaustion of administrative remedies were essential to a court's jurisdiction in a Chapter 21 claim under Texas law. So a failure to exhaust those remedies was a jurisdictional defect. Texas court would not have proper jurisdiction to hear a case until those remedies were exhausted, and jurisdictional arguments can be made at any time throughout a lawsuit. This has been in question in Texas courts in the past, but had not yet been specifically overruled. Recently, though, a U.S. Supreme Court decision interpreting Title VII, Fort Bend County v. Davis. In that case, the court held that Title VII's administrative charge requirement was not jurisdictional. It seems likely that Texas courts may now follow this precedent that's set by the Supreme Court. So since it's not jurisdictional, that court held it's just mandatory and it must be timely argued. So for practical purposes, hopefully we're ensuring that administrative remedies are always exhausted anyway, but would be even more important to pay attention to exactly what is pled in a charge and to timely argue a plaintiff's failure to exhaust administrative remedies if Texas does adopt that rationale. Another issue we see at the charge stage is the question of what exactly a plaintiff alleges, specifically related to retaliation. So an employee could file a charge based on race discrimination, later allege that he was retaliated against because he filed that first charge. In Texas, the Gupta rule says that that individual is not required to file a second charge of discrimination if the alleged retaliation is based on the filing of the first charge. However, some recent Texas case law has carved out an exception to this rule. If the subsequent adverse action is retaliatory and discriminatory, you must file another charge that alleges both. So a note for employers to be careful here as well. So as you know, the charge must allege all causes of discrimination before a lawsuit is filed. So if retaliation is not properly alleged in the charge, you want to make sure that you don't address retaliation in your response. The case of Apache Corporation v. Davis found that even though retaliation wasn't properly alleged due to this exception to the Gupta rule, that the employer addressed it adequately in the response and knew that it was at issue, and that cured the defect. So if the cause of action is not charged, be sure not to address it. Some additional administrative procedure issues. One issue we saw addressed in Texas courts recently dealt with timing in administrative procedures. Oftentimes we see charges or lawsuits filed right up to that deadline that are set by the EEOC or the TWC. Recent Texas case law determined that the clock begins to run at the time that the employer notifies the employee of the decision to take discriminatory action. In the MD Anderson case, the clock began when a plaintiff was given the notice of intent to terminate, not the later date when an actual final decision was processed. In Reyes, time began to run when the district board informed the plaintiff that it had accepted the superintendent's proposal to terminate her employment. The use of the word proposal did not alter the fact that the board was making that decision and still stood on that day, even though it was subject to further appeals by the plaintiff potentially. I want to compare, though, this Edinburgh case, where the time for a charge began to run when a school district's board of trustees voted to terminate the plaintiff's employment, not on the earlier date when the district superintendent informed her that she would be terminated. The superintendent lacked the power to actually terminate her employment, so it did not start the clock in that case. As you know, there's also a time limit on when a plaintiff must file suit after receipt of a right to sue letter from the TWC. Now, this clock begins when the first proper valid notice is received. In the Cedillo v. McAllen School District case, plaintiff received a first notice of right to sue from the TWC that was deficient in form because it failed to include a reason for the dismissal, a second notice that amended and cured the first notice, and then a third notice that confirmed the plaintiff's appeal to the EEOC and subsequent dismissal by the EEOC. The court held in this case that the second notice that amended and cured the first was the notice that triggered the 60-day time limit for judicial action under Chapter 21. This was the first proper valid notice of a right to sue. The employee's EEOC appeal of the initial determination does not toll that 60-day time limit for a lawsuit under Chapter 21, and a TWC notice confirming the EEOC's rejection of that appeal does not restart the running of the time limit for an action. Okay, I want to talk about some comparative evidence that we see used in discrimination cases. So Texas courts generally follow federal precedent with respect to rules for proving discrimination, but one recent case illustrates a possible deviation with respect to the McDonnell-Douglas inference of discrimination in discharge cases. The usual function of the McDonnell-Douglas inference in a discharge case is to create a suspicion of discrimination based on an employee's discharge from a position that still exists and for which the employee was qualified. So an inference of discrimination can arise in part from the employer's subsequent search for a replacement, so the job wasn't eliminated, or from the employer's replacement of the plaintiff with a person outside of that plaintiff's protected class. The employer must then explain its actions, and this comparator evidence is one way a plaintiff can create an inference of bias. A Texas court recently rejected this model of proof and held that no, under Texas law, a discharged plaintiff's prima facie case must identify a similarly situated person who was not disciplined as severely for the same conduct. Now, this is much more difficult to do. In the Romali case listed here, the employee could not identify another employee who had displayed the same misconduct that he did, a mandatory comparator, so summary judgment was granted for the employer in that case. Sticking on comparative evidence here, Texas courts use the nearly identical test to disqualify comparators whose status, misconduct, or disciplinary action were not nearly identical to the plaintiff's status, misconduct, or disciplinary action. In contrast, in discriminatory selection cases involving hiring or promotion, the courts typically have applied a clearly more qualified standard for comparing the plaintiff with the successful candidate. But in Smith v. Harris County, the court applied the nearly identical standard in a discriminatory promotion case and required the plaintiff to prove that his qualifications for promotion were nearly identical to the successful candidate. Naturally, the plaintiff and the successful candidate were not nearly identical in their backgrounds and qualifications, so the Court of Appeals affirmed summary judgment against the plaintiff. Now, this is a much tougher standard in discriminatory selection cases than the clearly more qualified standard that we're used to seeing. All right, I want to switch gears here, talk about sex discrimination. Now, as many of you probably saw, in June 2020, the U.S. Supreme Court decided in a 6-3 decision that Title VII prohibits discrimination based on sexual orientation or gender identity. The court recognized that sexual orientation and gender identity are distinct concepts from sex, but decided any decision based on sexual orientation or gender identity necessarily entails discrimination based on sex. This case resolved a circuit split. The Fifth Circuit had actually previously decided that sexual orientation was not protected under Title VII. Many states have enacted protections for workers based on sexual orientation previously, but Texas was not one of them. So this ruling is certainly something to keep in mind moving forward. Sticking with sex discrimination here, the Supreme Court of Texas had its first occasion to address same-sex sexual harassment in the Alamo Heights Independent School District v. Clark case. Remember that harassment is illegal discrimination only if it is because of sex or some other protected characteristic. Harassment that is merely about sex is not standing alone sex discrimination. In Clark, both the plaintiff and the harasser were women. Much of the harassment involved vulgar language and conduct that was about sex, but it was not clear that the harassment was because of the plaintiff's sex. The Supreme Court upheld summary judgment for the employer in this case. The court did identify 3 ways that harassment might be sex discrimination. So first, if it's motivated by sexual attraction, there is a presumption that a harasser's sexually suggestive harassment is motivated by sexual attraction if the target is of a different sex, but that presumption does not apply in same-sex harassment. Second, same-sex harassment might be illegally discriminatory if the evidence shows that the harasser's hostility towards the victim's sex. And third, same-sex harassment could be discriminatory if the harasser harasses only persons of one sex and not the other. So if we don't have an equal opportunity harasser, as they say. Thanks for listening to this legal update. And now I'm going to turn it over to Leslie to talk about some local pandemic orders and the impact those are having on employers.
Thanks, Cooper. Now I'm going to turn to the state and local COVID-19 orders impacting employers in Texas, go through the timeline of the state closing and reopening process, and discuss where we are now in the local orders. And then Cooper will go over some of the issues employers may run into in the recent changes to unemployment benefits in Texas. So on March 13th, Governor Abbott declared a state of disaster for all 254 Texas counties. Throughout the following week, several local officials began issuing orders limiting public gatherings and instructing the public to stay home. On May 1st, Texas began the first phase of Abbott's reopening plan, which ordered that retail stores and dine-in restaurants could resume operations but must be limited to 25% of the maximum capacity. After public pushback, Abbott announced that salons could reopen on May 8th and gyms could reopen at 25% capacity on May 18th, provided that they follow certain health protocols. The reopening continued with phase 2 on May 22nd, when Abbott permitted office buildings and bars to reopen at 25% capacity and restaurants to expand to 50% capacity. At the beginning of June, and just a few days after the protests had begun, Abbott announced his phase 3 plan of reopening, which permitted businesses and bars to expand to 50% capacity on June 3rd. In mid-June, though, cases and hospitalizations rallied upward at a much quicker pace. At that time, Behar County officials tested Abbott's provision against face mask requirements by putting the fine on the businesses instead of the individual. And on June 17th, the governor signaled his approval of local governments imposing fines on businesses that do not require face masks. In the week following the governor's permission, other major counties in Texas followed suit and issued new mask mandates. On June 26, Abbott renewed his lockdown orders, limiting restaurant capacity to 50% and closing down bars. On June 2nd, Abbott took his sanction of mask mandates a step further and issued a statewide mask mandate that made individuals liable for fines. The order requires every person to wear a face covering when inside commercial buildings and outdoor areas where social distancing is not possible, and is applicable to every Texas county with 20 or more positive cases. Notable exceptions to this order include children under the age of 10, anyone consuming food or drink or seated at a restaurant, any person who is voting, assisting a voter, serving as a poll watcher, or actively administering an election, and any person who is providing or obtaining access to religious worship. Throughout the month of August, the number of COVID-19 new and active cases, hospitalizations, and fatalities began declining. So where are we now? On October 17th, Governor Abbott held a press conference issuing a new executive order expanding occupancy levels from 50% to 75% for most of Texas, effective September 21st, for restaurants, retail stores, office buildings, manufacturing facilities, gyms and exercise facilities, classes, museums, and libraries. At the same time, Governor Abbott said that the state was not yet ready to reopen bars. The order will remain in effect unless modified, amended, rescinded, or superseded by the governor. This expanded occupancy excludes areas with high hospitalizations, defined as any trauma service area that has had 7 consecutive days in which the number of COVID-19 hospitalized patients as a percentage of all hospitalized patients exceeds 15%, until such time as the TSA has 7 consecutive days in which the number of COVID-19 hospitalized patients is less than the 15%. And using this metric, 19 of the 22 trauma service areas in Texas qualified to increase their occupancy levels to 75%, and the 3 that didn't were Victoria, Laredo, and the Lower Rio Grande Valley, which must remain at 50% occupancy. And this website, the opentexas.gov, has very useful checklists for different industry types for the protocols to follow and safety recommendations.
We have a poll question for you here. It's how many of your employees are currently working remotely? The answers are all of them, none of them, some of them, or most of them. I'll give you a second to answer. So here are the results, and we're currently seeing a mix with our clients, of course, based on the industry type and the need for people to actually be at the workplace.
Now I'll go over some of the local orders requiring face coverings and a health and safety policy. And there's a lot of different local orders and county and city orders in Texas, but in this presentation, I'm just going to cover the ones in the major or metropolitan areas. So the Travis County order came out on August 14th, and it continues through December 15th unless extended. And this order requires all commercial entities in Travis County that provide goods or services directly to the public to develop, post, and implement a health and safety policy. And the policy must at least require all employees and customers to wear face coverings while inside the business premises or other facilities. The health and safety policy must be posted in a conspicuous location to put all employees and customers on notice. So for all of the orders that we're going to get through, they all require this health and safety policy, and all of the policies must, at a minimum, require face coverings for employees and customers, and they must be posted in a conspicuous location. So there's nothing unusual about this policy. It's what we'll see all the way through. The City of Austin has a similar one, and a violation may result in a fine not to exceed $1,000 for the business. So now Dallas County had an order that came out on August 4th that's effective until modified, amended, or rescinded. And this also requires all commercial businesses providing goods and services directly to the public, which, just as an aside, providing goods and services directly to the public probably would not include your office building type companies, but more your storefront type businesses. And they require the health and safety policy and the requirement for face coverings and being posted in conspicuous location. And they impose a $500 fine on businesses. But something unique about Dallas County is they came out with a supplemental order on August 4th that will be in place unless modified or amended or rescinded. And it requires employers excluding hospitals and healthcare providers. It prohibits them from implementing any rules making a negative COVID-19 test or a note from a healthcare provider a requirement before a COVID-19 recovered employee can return to work. Also, employees of private businesses and nonprofits with 6 or more employees in the city of Dallas can use their paid sick leave when they are sick or to care for sick family members. Now turning to Houston and Harris County. On June 19th, Harris County came out with its order requiring the health and safety policy. However, it expires on June 30th. It has already expired and it has not been extended or renewed. However, Harris County remains at a level 1 on their threat level system. And level 1 signifies a severe and uncontrolled level of COVID-19. At this level, residents are encouraged to minimize contacts with others wherever possible and avoid leaving home, except for the most essential needs like going to the grocery store for food and medicine. Houston still does have its order in effect though, and that came out on June 29th. And it requires the health and safety policy, which also requires the face covering requirement, and that it be posted in a conspicuous location, and it has a $200 to $2,000 fine associated with it on businesses. Now last, I'll look at the San Antonio Behar County order. The San Antonio order came out on August 18th, and it's also effective unless rescinded, and it requires businesses to have the health and safety policy, but, which requires face coverings, but something unique about it is that it also requires that the business prominently display a list of COVID-19 symptoms at or near the public and employee entrances of the premises. Behar County has an order that was renewed on September 21st and continues until October 28th that also requires the health and safety policy And that policy would require face coverings and also must have that list of COVID-19 symptoms at or near the entrances. And both San Antonio and Bexar County have a $1,000 fine associated with it. Now I'm going to turn it over to Cooper to discuss some issues employers may run into with these local orders and also some of the recent TWC changes to unemployment benefits.
Thanks, Leslie. I'm going to now cover unemployment issues that could affect you as employers and some frequently asked questions that we're seeing most often. As you likely know, in March of this year, Congress passed the CARES Act, which provided an additional $600 per week to unemployment claimants due to the impact of COVID-19. This additional $600 was automatically added to qualified accounts for the weeks ending April 4th through the end of July. This did end though at the end of that month, and it's unclear if any additional federal funding will be provided at this point. State benefits, however, have continued in Texas. As Leslie mentioned, the governor declared a statewide disaster in the midst of this pandemic, and the Texas Workforce Commission exercised its authority under that declaration to waive unemployment insurance work search requirements. So previously, to be eligible for unemployment benefits, applicants were required to register for work search on workintexas.com and show that they were conducting a minimum number of work search activities during that week and trying to gain employment. The TWC is temporarily waiving those requirements to ensure that all Texans have access to the resources they need and try to combat the impacts of COVID-19. The TWC also suspended the waiting week that previously required applicants seeking unemployment to have that week of waiting before they actually receive their benefits. And that suspension is in effect until it's either terminated by the governor or when this disaster declaration is lifted or if it were to expire. There are a few concerns that employers are having, including a smaller pool of workers returning to work and then what incentives that might create with these changes in unemployment. Now, this could be caused by a fear of COVID-19 or the easier means to receive unemployment now. I know many employers were fearful of employees not only wanting to work remotely from here on out, but if they were incentivized to leave the workforce altogether with these new unemployment benefits. There has been a federal study that found no correlation between an employee's desire to return to work and that $600 unemployment boost, but remains to be seen if there will be long-term effects, either nationally or just in Texas specifically. You may also be concerned about a hike in unemployment taxes. It seems that like this could be a result of the rise in unemployment numbers. Not only is the TWC paying out way more in unemployment than they ever expected, but a recent report showed that upwards of 203 million have gone out as overpayments to employees in Texas. So the TWC has said they're trying to recoup this money, but with so many benefits paid out either way, a spike in unemployment taxes for employers is certainly a possibility in the future. Luckily, we're seeing that unemployment rate drop. It's about half of what it was at the end of May now, so hopefully that trend will continue. Okay, some FAQs that we have here. There's been so many changes in new policies and practices this year due to the COVID-19 pandemic. I'm sure you all have had many questions, and we're getting a lot too, so I'm going to go over some of the most frequently asked questions that we're seeing and the impact that these state and local mandates may have on those questions. So first, do employers have to provide their employees with face masks? We're seeing lots of questions about masks. We'll check your local ordinances, but in general, no. So this is not a Texas statewide requirement, and we have not seen major cities in Texas require employers to provide face masks to their employees. We are seeing that elsewhere, but not yet in Texas. However, they are required to wear them in the workplace, and we do actually recommend providing face masks if it's possible or if that's something you're considering for a few different reasons. First of all, this can help to ensure that employees are using proper face masks, eliminates the risk of employees showing up with face masks that do not fit the proper standards, avoid any uncomfortable or unsafe situations with employees. And further, we especially recommend this if you have a dress code in place. For customer-facing employees, a clean uniform mask is beneficial to you as the employer. We have also already seen cases arising that involve employee-made masks displaying logos or text that the employers do not approve of. A teacher in San Antonio recently made news claiming that she was fired for wearing a Black Lives Matter mask, and we have already seen unfair labor practice charges filed with the NLRB for employer restrictions on face masks. There are many concerns and considerations to look into here with masks that might make a statement under the federal labor laws. The NLRB has consistently held that political statements may be restricted at work, but recent guidance clarified that the BLM movement is not a political organization, for example. And in fact, employees could argue they're making a statement regarding harassment or equality in the workplace, or speaking to a term or condition of employment that is expressly protected under Section 7 of the NLRA, which protects both unionized and non-unionized workplaces. It's obviously a new and developing issue, and it seems masks could become the modern day union buttons perhaps, but certainly something to keep an eye on and properly prepare for as we do return to work. We're also seeing questions on the types of masks that employees wear. So N95 masks are PPE used in many factory settings designed to prevent hazardous materials from reaching the person wearing that mask. There's some OSHA standards that come along with these N95 masks. Surgical or medical masks have some specific benefits. Many of us now have cloth or homemade masks that grandma's been knitting and mailing to us. We see face coverings worn around the neck that can be lifted up to cover the face, or even those plastic face shields. So don't get me wrong, I'm all for stylish masks. I have a different color for every day of the week, but providing those masks to your employees can eliminate some potential problems and provide uniformity in the workplace as well. Second FAQ that we're seeing a lot here is what the requirements are for these health and safety policies. So as Leslie touched on earlier, many local ordinances require that employers implement a health and safety policy related to COVID. And at a minimum, these orders typically require the policy to require all employees and customers to wear face coverings while in the building and to be posted in a conspicuous location to put all employees and customers on notice. Good idea to check your locality first. Many places have produced sample health and safety policies that can be used as a guide for employers. And of course, every workplace is different, so we recommend tailoring this policy to your specific work environment. Some localities have other specific restrictions. In Dallas, for example, you cannot make a negative COVID-19 test or note from a healthcare provider a requirement before a recovered employee can return to work. That's outside of a healthcare setting. Other localities don't have that specific rule, but many reasons why a rule like that could be problematic. These policies could outline the procedure for returning to work after you've either tested positive or just been potentially exposed, sanitation procedures, social distancing practices, and things like that. There's many issues that come up as we return to work now, and issue spotting and planning ahead for as many of these as we can with a detailed, comprehensive policy is certainly.
Our next poll question here, do you have a comprehensive health and safety policy related to COVID-19? Should see 3 answer choices. If yes, you have that policy. If you have some policies and procedures in place, but not a comprehensive policy, or no. So choose which one applies and hit submit. Okay, got our results in here, and typically we're seeing mixed results from our clients.
For our last FAQ here, does a policy that requires employees and third parties to wear masks on the premises protect your business from liability? Potentially, yes, it definitely could. Of course, we cannot control if a lawsuit is brought against you. That's a risk all the time, whether we're in a pandemic or not, but a policy can reduce the likelihood that a suit is brought or that it will be successful. You can reduce the likelihood that liability will be imposed by following the most up-to-date mask guidelines published by the CDC, OSHA, in addition to Texas state and local ordinances. Now, many claims, including class actions or unfair labor practice charges that can be most costly to employers, are related to workplace safety claims that allege the employer failed to provide a safe workplace. Adopting a mask policy is one way to demonstrate to employees that you are prioritizing their safety in the workplace. As in other employment cases we see all the time, a policy that is implemented and followed properly can go a long way in preventing lawsuits and defending them when they do arise. Of course, COVID is a new phenomenon, and employers are sure to see many new and creative lawsuits related to COVID-19, but proper policy is a good way to stay ahead of this. Also note, health and safety policies and mask requirements are not a one-size-fits-all situation. It's always important to think about your specific workplace. There can be exceptions even to these local or state ordinances. Some healthcare settings have different and specific requirements. Some work settings may not allow for masks to be worn if there's risk of heat-related illnesses or other safety hazards that are at play. You may have employees that have trouble breathing or other medical needs that request an accommodation. We'll have to think through those sort of issues as well. This is just the tip of the iceberg when it comes to returning to work during COVID-19, but hopefully this overview of state and local ordinances and some FAQs surrounding COVID-19 can make this difficult time a little easier. Now send it back over to Kevin for our next topic.
Thanks, Cooper. I'm going to shift gears a little bit and talk about sick leave issues in Texas. As many of you guys know, like COVID issues, there's been a lot of back and forth over paid sick leave in Texas over the last year or two. So we're going to walk through the current requirements under Texas law concerning sick leave, talk about some trends that we're seeing from other states, talk about the status of various local ordinances that have been enacted, some related litigation. Then Leslie's going to pick up and talk about how the pandemic plays into all these issues, and then also what paid sick leave may look like after
Okay, and here's our last poll question for the day. Do you provide paid sick leave to your employees? Yes, no, or it depends. So go ahead and select one of those, please, and hit the submit button. We'll give you a few seconds for the results to come in. Okay, so as I expected, most of you answered either yes or it depends. And if it depends, it likely depends on how long they've been working for you, what their job classification is, things of that nature.
Even though I think most employers in Texas, or certainly many employers in Texas, do provide paid sick leave to their employees in some form or fashion, there is currently no Texas statewide or federal law that requires employers to do so. Obviously, remember, there may be unpaid leave requirements if an employee is FMLA eligible. Leslie's going to talk a little bit about the Families First Coronavirus Response Act and COVID-related paid sick leave. But most employers do provide some form of PTO or paid sick leave. No Texas, no federal law requires you to pay that out when their employment ends. If you have a policy that says you do or you don't, or whatever your past practices have been traditionally, that's what will control that issue. But nothing that requires it under Texas law statewide currently. So here we've got a map of the U.S. that shows states in which employers are required to provide paid sick leave. There's a growing trend amongst states on the West Coast and the Northeast, Michigan's there, in which employers are now being required to provide paid sick leave in some form to their employees. The stats there next to the map, the Pew Research Center has come out and said it looks like about 24% of working Americans don't have paid sick leave in any form. And really this issue has become a hot topic. It's been a hot topic for a while, but with the pandemic, there's now much more discussion around it, because the thought is, if people don't have paid sick leave and they need to come into work so that they can pay their bills, they may come into work when they're sick, and maybe that they are COVID positive, and that has the risk to further spread the virus. Of course, these issues were going on in California, Washington, the Northeast, well before the pandemic, and there was a lot of discussion in Texas well before the pandemic around these issues as well. So you see, in the past 2 years, the city of Austin, the city of Dallas, the city of San Antonio, they've each passed ordinances that require employers to provide paid sick leave to employees. Each of the three ordinances are similar in that employees are supposed to accrue or would have accrued 1 hour of paid sick leave for every 30 hours that they worked. The ordinances differ some in terms of thresholds, in terms of number of employees, how fast or when the sick leave accrues, whether there's caps on the sick leave, but generally the ordinances are pretty similar. So at the local level, citywide, there was a lot of opposition in Austin, Dallas, San Antonio from local business groups over this. Obviously those business groups were unsuccessful in opposing it because the ordinances were ultimately put into place. So the next step, the employer groups, the business groups, lawsuits were filed. There was an effort in the Texas legislature to overturn these paid sick leave ordinances. Most folks thought that the legislature would overturn the ordinances, and they got really close to doing it, but things got kind of bogged down after that proposed bill left the Senate. There was a fight over whether the legislation should include some language in it whereby LGBTQ employees are protected from discrimination. There was no agreement reached on that, so the legislature wasn't able to enact its bill. The ordinances were still in place. Then there's these lawsuits that came out of it as well. 3 different lawsuits filed by business groups, joined by the Texas Attorney General, all challenging the constitutionality of the paid sick leave ordinances. And the argument was essentially, in all 3 cases, that paid sick leave would effectively raise the minimum wage in Texas because it would require employers to pay over what the minimum wage currently is because they now have to give this additional sick leave. And the employers say, look, the legislature has already set a cap on, or has already set a uniform minimum wage. And if you take this out of the legislature's hands and put it into local cities' hands, that violates the Texas Constitution, because the Texas Constitution prohibits a city from passing an ordinance or a law that conflicts with statewide law. So that was the argument in a nutshell. In response, the employee side groups who were in favor of paid sick leave, they made a bunch of procedural arguments. They made a bunch of constitutional arguments as well, really voicing their opinion that everybody in Texas should have the right to paid sick leave. Ultimately, the business groups prevailed. Here's a sort of chronology of the local city council and court actions. You'll see Austin passed its ordinance in February of 18. A couple months later, San Antonio passes its ordinance. Litigation over the Austin ordinance was the first filed. The trial court in Austin actually ruled that the ordinance was constitutional. The Austin Court of Appeals then came back and said, no, it's not constitutional, based on that same logic that I just talked about, the conflict between state law and local law. Dallas, after the Austin court ruled it was unconstitutional, passed its own ordinance. The San Antonio court, you'll see, then San Antonio court struck down the San Antonio ordinance, issued an injunction right before it was supposed to start on December 1st. A federal judge in Dallas, Dallas ordinance went in effect in August of 2019, but it had a grace period until April 1 of 2020. So sort of no harm, no foul if you didn't comply during that period. The day or two before that ordinance was supposed to go into effect, a federal judge issued an injunction blocking the Dallas ordinance. And here recently, the Texas Supreme Court looked like it was going to hear the Austin case and maybe, issue a ruling that would resolve this issue on a statewide level. Sort of without explanation, in June, it announced that it was going to decline to do so. So all these 3 cases are still going on. The ordinances are still sort of in legal limbo because these injunctions that have been issued are just temporary in nature. These cases could proceed to a final judgment. I thought this quote from Judge Jordan in the Texas case summarized nicely the rationale by the 3 courts for finding these ordinances at least temporarily enjoined because of their unconstitutionality. Whether or not paid sick leave requirements should be imposed by government on private employers is an important public policy issue, made even more significant by the pandemic. And then he says, the state of Texas, through its constitution, through its statutes, has decided that that's a public policy decision for the legislature, not for individual cities. So again, temporary order, something else could happen in the case, but right now it's looking like those various ordinances are going to ultimately probably be declared unlawful on a permanent basis. I think employers should keep an eye on those three cases. Certainly, if you have employees in those three cities, keep an eye on what the legislature does in the coming session in 2021. I imagine this is going to be an issue that's addressed. So continue to monitor the situation. This is an interesting issue. I'm not sure exactly how it'll shake out, but I'm going to turn it over now to Leslie, who's going to talk more about how COVID interplays with these issues and what we're seeing on leave issues out of the pandemic.
Thanks, Kevin. Now I'm going to talk a little bit about how COVID-related leave mixes in with those issues and what we might see on a federal level related to paid leave following the election in November. So the Families First Coronavirus Response Act came out in April 2020, and it expires on December 31st, 2020. And it may provide paid leave to your employees for COVID reasons. It applies to private entities with less than 500 employees and all public entities unless exempted. One part of it is the Emergency Paid Sick Leave Act, which allows employees 2 weeks of paid sick leave, and there's no minimum employment tenure for eligibility. And the other part of it is the Emergency Family and Medical Leave Expansion Act, which allows employees affected by school closures to take up to 12 weeks of FMLA leave. And employees are eligible for that after 30 days of employment. Now I'm going to go through some of the recent updates. So the work availability requirement was updated in September 2020, and the DOL's new regulations reaffirm that employees may only take leave under the FFCRA if the employee has work from which to take leave. The DOL also asserted that leave is intended to mean time that someone is missing work when there is work available. However, the regulation does explain that the work availability requirement does not allow employers to claim lack of work in order to deny leave, and points to the anti-retaliation and other protections provided to employees by the law. Another question asked by many employers is whether all entities in the corporate family or employees of staffing entities are counted when determining the 500 employee threshold. The FAQs explain that two tests are relevant: the joint employer test and the integrated employer test. And based on a revision to the FAQs on March 29th, both of these tests apply to both forms of FFCRA leave. An employer's employee count must include all joint employees if the employer meets the DOL's newly amended joint employer test under the Fair Labor Standards Act. In addition, the DOL clarified in its guidance that joint employees employed on an employer's premises, such as staffing agency employees, are eligible for leave under the FFCRA. Also, an employer comprising multiple entities could have its employee count aggregated across the entities if it meets the integrated employer test under the FMLA. Again, this test, like the joint employer test, applies both to determining employer coverage for emergency paid sick leave and the emergency FMLA leave. And this integrated employer test relies on multiple factors, including the degrees of common labor relations, management, operations, and ownership. Intermittent leave was also clarified and addressed recently in September 2020. And whether the employee can take leave intermittently is dependent on whether the employee is teleworking or working at his or her usual work site. One basic condition applies to all employees who seek to take the paid sick leave or the emergency FMLA intermittently, which is that the employee and the employer must agree on an arrangement. And unless the employee is teleworking, once the employee begins taking leave for an emergency paid sick leave qualifying reason, the employee must continue to take the paid sick leave until the employer either 1, uses the full amount of paid sick leave, or 2, no longer has a qualifying reason for taking paid sick leave. And by contrast, an employee may take the emergency paid sick leave or emergency FMLA on an intermittent basis if the employer allows it, and if the employee is unable to telework due to care for a child whose school or child care provider or facility is closed due to COVID-19 related reasons. And then the DOL also recently clarified the definition of healthcare providers, So the FFCRA permits employers to exclude healthcare providers and emergency first responders from eligibility for benefits under the emergency paid sick leave and the emergency FMLA. Healthcare providers initially had a much broader definition than anticipated. It included both a wide variety of healthcare positions, as well as other employers by institutions such as doctors' offices, hospitals, healthcare centers. And a New York federal court struck down the DOL's expansive definition of healthcare provider, finding that it unduly restricts benefits to workers intended to be covered by the FFCRA. The court directed the DOL to the FMLA definition, which is much narrower. The DOL and its amended regulations clarified the definition of healthcare provider, adopting a middle ground approach. Now, a healthcare provider, for the purpose of the FFCRA leave exemption, includes those covered by the FMLA definition, as well as other employees who are employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care. The following types of employees are specifically included in the new definition, in addition to those who were included in the FMLA definition: nurses, nursing assistants, medical technicians, and similar roles who provide direct services to patients. The amended regulation also provides examples of the types of employees who are not considered healthcare providers, such as IT, maintenance, human resources, food service, records, and billing, for example. The DOL reasoned that the purpose of the exemption was to ensure that the healthcare systems can continue to function. Now, just some other things that employers should keep in mind that might come into play with COVID-19 leave is other employer paid leave policies. So under the Emergency Paid Sick Leave Act, employers may not require employees to use vacation, PTO, or other forms of paid leave before using emergency paid sick leave. And under the emergency FMLA, although employees may substitute any available paid leave, such as earned PTO or vacation, employers cannot require them to do that. You also have to consider just an unpaid leave of absence and traditional FMLA, which could be in addition to it. And if you provide short-term disability, that could also come into play in addition to the COVID leave. Now looking forward to how things might change after the election, Biden on his campaign website says that his plan is to permanently provide the type of comprehensive 12 weeks of paid family and medical leave envisioned in the Family Act sponsored by Senator Kristen Gillibrand and Representative Rosa DeLauro. And this would provide 12 weeks of paid leave for all workers for their own or family members' serious health condition. He also states on his website he wants to provide the type of coverage in the Healthy Families Act spearheaded by DeLauro and Senator Patty Murray, which would provide workers with 7 days of paid sick leave for routine personal and family health needs, as well as time for survivors of domestic violence and sexual assault to seek services. In addition, his plan includes a COVID-19 emergency plan that will require 14 days of paid leave for those who are sick, exposed, or subject to quarantines, and states that employers would not bear any additional costs for such additional leave. The paid leave plan will create a federal fund to cover 100% of weekly salaries or average weekly earnings capped at $1,400 a week, the weekly amount that corresponds with about $72K in annual earnings. And this paid leave would be for sick workers, workers caring for family members or other loved ones, for people unable to continue work because they are at increased risk of health complications due to COVID-19, paid leave and childcare assistance for dealing with school closings, and paid leave for domestic workers, caregivers, gig economy workers, and independent contractors. And the emergency plan would provide reimbursement to employers or, when necessary, direct payment to workers for up to 14 days of paid sick leave or for the duration of mandatory quarantine or isolation. And this would be in addition to existing paid leave provided by businesses' existing policies. And President Trump recently extended paid parental leave for federal employees to provide 12 weeks of paid leave. And other than what's already been put under place under the FFCRA under his administration, there's not been much talk on his campaign about new paid sick leave programs. However, he has indicated support for paid parental leave for new mothers. Thank you for joining us today. We hope that the information was helpful to you and your organization. As a reminder, please join us next week for our St. Louis, Illinois program. This program has been approved for HR and legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We value your feedback and to plan future programs that are applicable to your business needs. This concludes our webinar. Thank you.